One of the most common questions I get in a DUI case is, what did that officer read me off of that little card? Well, what he read was the implied consent notice. There's 3 different notices. If you're over 21, he's going to read the notice that says 0.08 grams or more. If you're under 21, he's going to read the notice that says 0.02 grams or more. And if you're a CDL driver, he's going to read the notice that says 0.04 grams or more. Implied consent is basically, if you drive on the roads in Georgia, that you have given your implied consent if you're asked to take the state's blood test, breath test, or urine test, that you've already given your consent. And if you refuse, your refusal can be used against you. That's where implied consent goes against all the law that the state of Georgia has had up until 1979, when the implied consent statute was brought into effect in Georgia. Now, if you refuse the official state test, that's the Intoxilizer 5000, Intoxilizer 9000, which is the new machine, or the breath or the blood or the urine test, and you are convicted of DUI refusal, or if you lose at an ALS hearing, the result will be a 12-month hard suspension of your driver's license. There'll be no privilege to drive in the state of Georgia. You can't get a permit and you can't get an early reinstatement. This is what I call the state's hammer. If there's a refusal, the state will use it against you and suspend your license for 12 months, a hard suspension.